All right. Okay. Hello. Thank you, everybody, and welcome to our presentation today with Britt Burner from Burner Prudenti Law. Our topic today is 2025, the year of trusts. And I am just going to, thank Britt for being with us today. We always appreciate her coming and doing these talks for the library. And I will give the floor right over to her to tell us about the year of trusts.
Yeah, thank you. Thank you so much. And thank you to the Shelter Island Library. It's always great to have good programming for the people who use your library, and especially to do so virtually is wonderful. So thank you. Um, it's interesting. We're calling this the year of trust, and that's really I just coined it that. So it's not that title for any reason other than I think it's a really good wake up call. The year's changing, and it's time to really be thinking about your estate planning and do you need a trust? And so, what we'll talk about today are different types of trust that might be helpful to you or to your loved ones. Our firm, Burner Prudenti Law, has offices as far east as East Hampton, as far west as Manhattan, and two offices in between. So there's four offices total, and these are the areas in which we practice. We do trust and estates, and we do elder law. And so the topics I'm going to hit on today are meant to cover those areas. This is not meant to be legal advice. This is meant to be educational. So I'm hoping that each of you can find a few things that apply to you in this conversation and then use it as you go forward and do your own estate planning with an attorney and get legal advice that applies to your specific situation. Our offices are all located in New York State, and we are all New York State licensed attorneys within our firm. We are not licensed outside of New York. And so a lot of the things I'm going to be talking about today, unless it's a federal law that governs it, and there'll be very few of those, and I'll mention it if there is. Otherwise, this is all going to be New York State based information. So if you live in New York, say you have a house on Shelter Island, but your primary residence is in Connecticut and you're a Connecticut resident, well, then you're going to need to talk to a lawyer in Connecticut to find out how this might differ in your state, as an example. So with all that being said, let me get started. So what is a trust? So a lot of people get confused about what it is and if they need it. A trust is first and foremost a document. It's a document that lays out the rules of the game. So the document creates an entity. So everybody knows what a will is, a last will and testament. It says, upon my death, this is what should happen. This is where the money goes. This is who's in charge of it. And all of that's within the will document. Oh, trust should say that as well, what happens after you die. But the difference is that a living trust is a trust that's created while you're alive, and it creates an entity and you actually put things into it. So a great example is a house, right? If Britt Burner owns a house and I decide to create a trust, well, then I'm going to sign a deed giving my trust to the Britt Burner Trust. And now I'm not the owner of my house. The trust is. Now, the trust might be such that I have full control over it, but the owner of title is my trust, not me. So a trust can own multiple things. So if you have a brokerage account, if you have a checking account, a savings account, a car, these items can all be owned by your trust. Now, depending on the type of trust you have and the type of controls you have over the assets in the trust, you may or may not want to put all of your assets in the trust. The main asset that we keep outside of the trust is any tax deferred retirement. We call them qualified plans. So if you have an IRA, a 401k, a 403b, a TDA, these are all retirement accounts that have been created pre-tax, and you're taxed on the distributions once you have to start taking them, and that does not go into the trust. That will remain in your name for your lifetime. So with a will, we have to go through this process called probate. So when I start to talk about trust, it's important to understand that one of the main reasons people create trusts is to avoid this process called probate. This is the process by which a will goes through the courts, is deemed valid, and there's no issue with it, and then the business of your estate can move forward. But what a lot of people don't realize is that all wills that need to be followed need to go to probate. So if you're a person with any asset in your sole name with no beneficiary, then your will is going to have to go through probate, because otherwise it's nothing but a bunch of pieces of paper. It needs that solid stamp of approval from the court saying this has been vetted through this probate process, and now it can move forward, and the executor can be appointed and do the work they have to do. So if I have a house that's in my name, a bank account that's joint with someone else, and an IRA with a beneficiary on it, then my IRA is going to go to the beneficiary. My joint account is going to go to the joint account holder. And then only my house will be subject to the probate of my will. So if the probate of my will says this is the person that will be executor and this is what should happen with the house, then that's what will happen. But for a lot of people, avoiding that probate process is important. One issue is just it makes your estate a public record. A will is a public record once it's filed for probate, as are many other documents that are part of the probate proceeding. So some people don't like that. They want the privacy. There are some inherent delays with the probate, depending on the county that you have as your primary residence at the time of death. That's where your will is probated. Obviously, counties that are much more populous, like once we get into Manhattan, the Bronx, have a lot, Brooklyn, it's a lot harder when it comes to probating a will because there's a lot more on the docket, right? So whereas out in Suffolk County, it moves a little bit quicker. But there's still a delay. There's still a time period in which nobody is responsible for the assets of your estate while this court proceeding is pending. And even in a case where there's no arguments and everybody's agreeing, there is still a delay based upon the process. And so many people like to avoid that. People also like to avoid probate if they are disinheriting one of their next of kin. Why? Because probate requires that you give notice to legal next of kin that the will is going through probate. So if I have a spouse and two children, my spouse and my children all need to get a copy of the will and know that it's going through probate. Now, let's say I'm disinheriting my spouse, or I'm leaving everything to one child and nothing to the other. There might be some people who are pretty upset about that. The people I'm leaving out might be upset. And they have an opportunity in the probate proceeding to show up at court and to contest the will and to contest the fact that probate goes through. And this can be time consuming and it can be expensive. So a lot of people like to avoid probate when they're not including a family member that would otherwise be entitled to notice. We also like to avoid probate if we don't know who our heirs are. So a lot of times people come in and see me and they said, I'm an only child, I'm not married, no children, my parents are deceased, I didn't have any siblings, and I think maybe I have some cousins, but I don't know, my parents never really talked about them. That's someone who may want to avoid the probate process because their entire estate will be held up by the requirement to find these legal next of kin, and it's a real requirement. We can't fudge it. We have to try and locate these people with a lot of very expensive efforts. And so it's very important in that regard as well. We also like to avoid probate if there's a disabled beneficiary, because the courts, if somebody can't represent their own interests, and now I don't mean any disability, but I mean a disability that leads to someone not being able to represent their own interests in the court, then the court is likely going to appoint a guardian ad litem, which is someone appointed to represent that person's interests. The same with minors. So if someone dies and they're leaving assets to grandchildren, or if someone dies and they have minor children of their own, then that could become a longer probate issue. The last reason of the main reasons why we like to avoid probate are if people own property in multiple states. So I started by talking about somebody who lives in Connecticut, has a house on Shelter Island. That person would have to have a probate of their will in both states, New York and in Connecticut. And so a lot of people are trying to avoid that, and that's where trusts often come into play. So there's two main types of trusts that I'm going to talk about today: revocable and irrevocable. And then within irrevocable, I'll talk about different types. But I'm going to start with the revocable. A revocable trust is a trust that you're fully in control of for your lifetime. You can revoke it, amend it, restate it. You can serve as trustee of the trust. It carries your own social security number. Now, you could always appoint someone else to be trustee if you don't want to do it, or if you want to say, now I'm older and I don't want to be trustee anymore and add someone in, but you are not, but you can't be told what to do with that trust. You are in charge of it. The purpose of a revocable trust is really only to avoid probate. It doesn't have any other benefits to it. So it doesn't have Medicaid protection. It doesn't have tax protection, anything like that. It's totally tax neutral. So what does that mean? It means, remember I said it has your social security number. So you can, for all tax purposes, income tax purposes, it's your property. Nothing changes. Again, only to avoid probate. So that's really the simplest thing. A lot of our clients also who are higher net worth, so those who know that they're going to have to deal with either New York State or the federal government or both in terms of having a taxable estate. Many of those clients like to have a revocable trust as part of their plan because having ready access to the money after death will make it easier to figure out what the tax is on the estate and then also to pay that tax, which is due 9 months from date of death on the state and the federal level. The exemptions are very high. In 2025, the New York State exemption is going over 7 million. And the federal will be 13.99 million. And these generally go up a little bit every year with inflation. And basically, if you're underneath those amounts, you don't have to worry about taxes. But if you're over, it's going to be an important part of your planning to figure out how to minimize or eliminate those taxes. The next type of trust would be an irrevocable trust. So my simplest way to describe an irrevocable trust is that it's a trust that you create that has some kind of a restriction in return for some kind of a benefit, right? Because we don't get anything for free. So if you're looking to get a benefit such as lessen your estate taxes, you need to lose access and control to those assets. If you're looking to remove assets from your name for Medicaid eligibility, well, then same thing. You need to then lose the access and control of those assets. So that's what an irrevocable trust is. It's something you're giving up in order to gain some type of benefit. But what you have to give up is going to be different based on what your benefit is. So again, taxes is one reason, Medicaid is another. Other government benefits for disabled individuals could be another. And so that will govern how the trust has to be written and what the rules of it will be. One of the most common irrevocable trusts that we talk about is the Medicaid Asset Protection Trust. And many people will put assets into this trust so that when they apply for Medicaid for either home care assistance, a home health aide, or nursing home care, that the assets in the trust will not be counted as theirs for eligibility purposes. Now, the key to this trust is that you can't have use of the money. Why? Because if I have $300,000 in a trust, Medicaid, and I can access it and use it for my care, Medicaid is going to say, great, then go get that money and let's use it for your care. Why are we paying for your care? So if you're doing a Medicaid trust, you have to be comfortable with the fact that you are moving assets out of your name into a trust that you don't control, and the trust reads that you cannot have the benefit of that money. It can't be used to or for your benefit. You can keep the right to change the trustees. You can keep the right to change the beneficiaries. So while you might not have control over the assets, there are still strings attached to you, and you're not in a position where you're giving assets away and they're totally gone. And in certain cases, you might still be able to access those assets through your other beneficiaries or your trustee, depending on the circumstance. You cannot change or amend or revoke this irrevocable Medicaid Asset Protection Trust unless you have the approval of all of your beneficiaries. So you can't just do that on your own, but you can amend or revoke an irrevocable trust in New York as long as all the beneficiaries sign off and agree. Very often people will take their primary residence and place it into the Medicaid Asset Protection Trust to gain that protection for these benefits. You cannot be required to pay rent for that property, but you are responsible for the maintenance. So just like now, how you pay for the landscaping and the taxes and mortgage and utilities, anything for the upkeep of the house, you're still responsible for all of that. However, if you do have a rental property, that you have a house that you rent out or an apartment that you rent out and you receive income, you can keep the right to receive that income. So whether it's income from an investment property, income from a brokerage account, interest and dividends, all of that income is yours. It's reported on your personal return. So you don't have to have a negative tax inference to having this trust, because for tax purposes, it's totally neutral. If you then decide you're going to move out of your house and you want to sell it, the trustee sells the house. The money from the sale the proceeds go into a bank account in the name of the trust. And those assets are protected from when you first place the house in the trust, not from sale. So it has that long-standing protection. And then the trust, depending on how it's written, but a trust can allow you to buy a replacement property so that you have somewhere to live. However, remember, you can't use the principal of the trust, so you can't pass money out of the trust to be used for rent, for example. The trustee, usually we recommend they open a bank account in the name of the trust so that the trust can pay, so that as money comes into the trust or upon sale, the money can be deposited into that bank account. And any capital gains tax that's owed on assets within the trust, once sold, any capital gains tax will be paid on the individual level as well. So for example, with your primary residence, if you purchased it for $100,000 and you sell it for $1 million, there's $900,000 of gain. Now we might be able to close the gap on that gain by adding in cost of capital improvements. You have a personal $250,000 exclusion based on it being your primary residence. So maybe in the end, if we say 250 if you're a single person, 500 if you're a couple. So let's say it's a couple, 500, their basis was 100, now we're at 600, and they put 100,000 in over the course of the time they own the property. Now you're at 700,000. So the capital gains tax will be paid on the difference between the 700,000 and the $1 million sale price. That money will go into the trust. However, the tax is borne by you as the grantor, the creator of the trust. Upon your death, the property will receive a step up in cost basis, just as if it was in your own name. So what that means is if I bought it at 100,000 and when I die, it's worth $1 million and I still own it, well, then the people who are inheriting it from me inherit it with a basis of 1 million. So if they turn around and sell it right away, there will be no gain and therefore no capital gains tax. And that is the same as if the property was in your name or in the revocable trust. It is still yours for all tax purposes. Now, once you have a trust, and I should say the irrevocable trust, it will say, while I'm alive, and these are the rules. And when I die, these are the rules. And this is who I want it to go to. We often say that when you're leaving assets behind, you might want to leave them in a trust for the people you're leaving it behind for. Let's say you have 2 children and everything's getting left to them 50-50. If you do it in a way that you're looking to protect them, the assets, they can each get their 50% share in a trust and they can be their own trustee. But should an issue arise where they have a creditor, a divorcing spouse, there are ways to distance them from the inheritance so that that is protected, even though you've left it to them. So we call those descendants trusts, and we very often are putting descendants trusts into our documents so that your beneficiaries are protected when you eventually leave assets behind to them. The other type of irrevocable trust that we often talk about is one for estate tax purposes. So again, if you're over those very high estate tax thresholds, you might be looking to remove assets from your estate to get a benefit on the estate taxes, to either minimize or maybe even completely eliminate any estate tax that might be owed. One example of that type of trust we call an ILIT, an irrevocable life insurance trust. That's the type of trust that says, okay, you've got a $2 million death benefit on a whole life insurance policy. I'm going to make it so that the owner of that policy is this life insurance trust, not you yourself. Because if it's owned by the life insurance trust, then it does not count when we're adding up your estate for estate tax purposes. So if somebody has a $5.5 million estate plus a $2 million life insurance policy, well, now they have a $7.5 million estate, and that is taxable in New York. As opposed to if they have a $5.5 million estate and we've moved the life insurance over into this life insurance trust, it does not count. It does not bring you over the exemption amount, and there's no tax on that estate. And by doing something like that, you could be saving an estate, even at the smallest numbers, $500,000 or more in potential estate taxes. So it's a really good thing to look at the assets and to see where you are in terms of that exemption level, and make sure you're adding in the value of life insurance and the death benefit of life insurance when making those calculations. So once you have a trust, it's really important that you maintain your trust. So first of all is maintain the physical trust, right? So often we have things scanned in, we have computer copies, but it's always a good idea to keep an eye on where your original trust is. You should know where it is. It should be somewhere where you can access it if you need to. However, an electronic copy is equally as good for the purpose of just reviewing it yourself. When you have a trust, you also want to make sure that who you've named as trustees make sense, that who you've named as beneficiaries still follow your wishes. So for example, if you have someone who's named as your trustee after you die to manage your estate, and that person isn't a friend anymore, or you got divorced, or whatever it may be, you may want to update that. So we generally recommend that every 3 to 5 years, people are reviewing their documents to see if there are any changes that are necessary. There may not be, but it's important to take a look. You can also change your beneficiaries. So sometimes people say, oh, well, I want to include these 5 people and give them a small gift. And then when they come back 5 years later, it's, well, I'm not friends with that person anymore, and this person may have passed away, and it might not make sense. So you want to make sure your beneficiaries still make sense. Most importantly, you want to make sure that you understand your trust. You want to understand what it says, what might happen, and have your attorney explain to you in regular language, if I die, then what? Right? What are the next steps? What's going to happen? And make sure that you understand your trust so that the people that you're naming have a chance at understanding it when you're not around anymore. It's really important to keep on top of that. I want to pause because I think there might be some questions here in the chat. So let's pause and take those.
Yeah, let's see. So, so the first question we have is for items like real estate, bank accounts, etc., not in trusts, what mechanism is available to include after passing?
So I think I understand that. I might have covered this a little bit at the beginning. So there's a few ways that assets can pass. Real estate different than bank accounts. So a bank account can either have a joint owner. It can have most accounts, not usually with checking, but many other accounts can have a beneficiary listed on it. So a joint owner, a beneficiary, or if it's in your sole name with no beneficiary, that's when it will pass through the probate of your will. Unless, of course, you create a trust and then you make the account be titled in the name of the trust. Real estate, I would say, goes in the category of you could have, there's varying ways you can hold your deed. So if you have a deed to a property, the question is first going to be, how do you hold title? So do you own it alone? Is there someone else's name on the deed, and what rights do they have according to how the deed is written? And then depending on how you want things to pass at your death, there are transfer on death deeds, which is a new law as of July 2024, which I think really have a limited purpose and value. There's a lot of potential issues with that type of deed, and so I would definitely get legal advice before attempting to do something like that. There's life estate deeds that say property is yours for a certain amount of time for your lifetime, with a diminishing value based on how old you are. So as you get older, your share of the property goes down, and then whoever you're leaving it to, their share will increase. That's called a remainder interest. And so, you could do a life estate deed, or again, if you have a joint owner, you want to make sure that it's one of the types of joint ownership that will pass through what we call rights of survivorship, as opposed to having to go through probate of your will. In New York, if you have two people who own a piece of property, so person A and person B own a policy to get own a house together, and it just says person A, person B, and it's silent on type of ownership. If those people are not a married couple, that is what we call tenants in common. Tenants in common means they each own 50%. And when the first person dies, their will has to go through probate to determine who's going to own their percentage. So it's very important not just to understand what's going to happen when you're gone, but to really understand how you own your property and what your options are if you do own it with somebody else.
All right, we have another question here. Um, okay, if a disabled niece on SSI is a beneficiary of co-op apartment shares in Medicaid Asset Protection Trust from an aunt, and is planning to sell their shares upon the aunt's passing, would the niece need first party S&T or could it be third party S&T?
Okay, so I'm going to answer this question by not exactly answering the question first. I'm going to explain what a first party and a third party are. A first party SNT stands for Supplemental Needs Trust. A supplemental needs trust is a type of trust created to protect assets so that somebody can receive government benefits, and the assets of the trust could be used to supplement those benefits. So it's not necessarily just Medicaid. It could be this person's on SSI, which is a form of supplemental income. So a first party SNT, though, would be created first party, meaning it's my money that I put into it. So for example, if I have $100,000 in the bank, I'm under 65 years old, and I want to move those assets to a trust so that I can get government benefits and that money can last longer, then it's my money. So I would create a first party SNT. But in this example, the person has a family member that's leaving them something that should always be left in a third party SNT. So if the aunt has a will or the aunt has a trust that leaves the co-op to this individual, it should be left to the individual in a trust. And the fact that the aunt's documents created that trust by itself makes it a third party SNT. We prefer third party SNTs when we can do it to a first party, because a first party has a payback to Medicaid at death, whereas the third party doesn't. So for example, this could play out two ways. If this individual is left this apartment in just in their individual name, then once they inherit it from the aunt, then it would have to go into a first party SNT. And they can use that money for their lifetime, but when that individual dies, Medicaid will be paid back from whatever's left in the trust. Whereas if the aunt leaves it directly to a trust, it's a third party SNT, if it's created as such. And when the person dies down the line, after the SSI beneficiary, when they down the line pass away, whatever's left in the trust will go to whomever the aunt had determined. So whether it's other family members or something. So it's really important that the aunt in this circumstance, or the parent, or whoever it is that's leaving assets to a disabled beneficiary, does so in a proper third party supplemental needs trust to further protect the assets.
Okay, then the last question I'm seeing here is, aren't insurance policies exempt from probate?
So whether or not something is exempt from probate depends on ownership and beneficiaries. So they can be exempt from probate, but they could also not be. And I'll give you some examples. So if you have a life insurance policy with no beneficiary, then when you die, it will go through probate. If you have a life insurance policy that names the estate of the individual, then also it will go through probate. If you would like to avoid probate on a life insurance policy, then the beneficiary listed on the policy should be named as a person. So if I want person A and person B to inherit my life insurance policy, then their names and their information will be on file with the company that holds my policy. When I die, they receive a death certificate, and those two individuals are contacted and they receive their money. So that's how you avoid probate, is by naming beneficiaries. Now, if I have, like I said before, a $2 million life insurance policy, and I'm the owner of the life insurance policy, and there's a death benefit when I die, well, then that's also part of my taxable estate. So if I want it removed from my taxable estate, that's when I started talking about irrevocable life insurance trusts.
Okay, I think so far, other question, just will this video recorder be available? Yes, this recording is going to be available when the link is ready. I will send it out to everyone who's registered.
Great.
Um,
Okay, so we'll
uh, oh,
oh,
can a third party S&T be revoked at any time?
no, a third-party S&T cannot be revoked at any time. Now, that being said, you might decide that the person no longer needs government benefits and you might distribute the assets. A lot of that's going to depend on what the person's disability is, why they need government benefits, and also how the money is being used in the trust, and how the trust is written. One of the things that I should have mentioned that I didn't before was that, with trusts, every trust is written differently. So I'm giving you pretty broad strokes here because these are the rules and these are the way things can go. But I have, just as much as I've seen trusts that say exactly what I'm telling you, I've also seen trusts for a stated purpose that really have are written in a totally different way, and the rules are different. So I'm giving you the broad overview of what these different trusts are, but in the end, anytime there's a question about a trust, the best answer is, let's go to the trust document, that document that was originally signed by the creator of the trust, and let's see what those documents say, and then that will tell us, remember I said at the beginning, what the rules of the game are. So you always want to go back to the trust document to see what it says. Okay, so one of the important things about trusts are what we call funding the trust. So it's all well and good to create the trust document, to move assets, and to to say what you want to happen and to lay out the structure and all of that. But just as important is the funding of the trust. So if I create a trust, but I don't transfer any assets into it, it might as well be that I didn't create the trust. All those assets would still be responsible to go through probate. So let's say I have a house in my sole name and I have a bank account, a checking account. I need to actually change the deed on that house to be in the trust, and I need to change the name on the bank account to be in the trust. Now, you might not want to put, for example, if somebody's going on Medicaid and we're doing one of those trusts, you don't want to put the regular checking account in the trust because remember, you can't use the money in the trust. So if this is the money that you're living on, that's going to be outside of the trust. So then we want to make sure that there's a beneficiary or a joint owner, because all of this, we use the term estate planning because the idea is that there should be a larger plan here. There should be a coordination of all of the different accounts where they're going. A lot of people don't realize that when they create an account with a joint owner, that they're essentially giving that account to the individual. And then if your joint owner, let's say they have a creditor problem, they're being sued or there's a judgment against them, your funds, your assets are now opened up to the individual you've named joint owner because it's just as much theirs as it is yours now that it's been created. So that's why I don't love the idea of joint ownership for solely this purpose. You have to look at all these other issues and make sure that it really does make sense to have a joint owner on those accounts. When you have say you own an LLC, you own maybe it owns a building that you rent out, or maybe it owns an operating company, anything like that. You want to also move the shares of the corporation into the trust. So the idea is, again, that the trust is going to be the owner of everything, so that when you pass, nothing is owned in your individual name, and we can avoid the probate process. So when we have shares of an LLC, we have real property, we sign a deed, we have bank accounts, we have brokerage accounts. Every asset that you own, you have to look at what the ownership of it is and move it into the trust, especially when you're doing a revocable trust for the purpose of avoiding probate. And, I didn't spend a lot of time on it, but, probate, again, it can be not that bad for some people. And then for others, it can really be a drawn out, long, expensive process. And so it's important when you're doing your own estate planning to sit down with a lawyer and say, how is this going to affect me? Or my beneficiaries, really, because you'll be gone. What is it going to look like when I die? Can you walk me through what the steps would be? And then you have to see if that's something you feel comfortable with, or if there's something you would want to happen differently. And I always tell people, you tell me what you want to happen, and then I'll let you know if we can work it into a legal framework. I could stop again and ask. I see there's some more questions that have come in.
Yeah, we have a question that asks, what do you think of a house on a TOD trust versus a revocable trust? Pros and cons.
So I think that person might be referring to a TOD deed. That is that new law that I was referring to that came into play in July, a transfer on death deed. So the problem with a TOD deed is that there's very little filing requirements associated with it. So for example, if I sign a TOD deed and I leave the house behind to someone, there's no requirement that I notify them that they're receiving the house upon my death. So depending on the circumstances, that could be problematic, and the person could find out that they own a house, when the house is going to foreclosure, because nobody's paid anything on it after death. So depending on the circumstances, that's certainly a concern. There's very little filing. I think there's concern that deeds can be signed without a lawyer, and a lot of things can be signed without a lawyer. People will do LegalZoom, but there's concern that there's not proper legal advice around it. There's also an issue with if I have two children and if I leave my property in a revocable trust or through my will to my two children, I can leave it so that if one of my children should die, their share goes to their own children, to my grandchildren, goes down the bloodline. But with a TOD deed, I can't do that. I can only leave it to the people who are named on the document. So there's no survivorship in that regard. And so it just might not follow the wishes of the individual. So I think that there's still a lot to be learned about TOD deeds, because we haven't even had the law for a full 6 months yet. But those are some of the concerns that we have. Whereas with a revocable trust, it's certainly more effort to set it up, because you don't just name a beneficiary, you have to create the whole trust document as well. But I think that there's more room for pivoting in the future and editing and taking care of situations that are a little more complicated. Also, with a revocable trust, I can leave the assets behind in a trust with that creditor protection. Whereas on a TOD deed, I don't have any opportunity to protect my beneficiaries. It would just go outright.
We have another question here that asks, is there any way that an annuity that was created with a 401k rollover could be protected if you want to become Medicaid ready in the event you need long-term care?
I hate talking about annuities. No, there's so many different types of annuities, so it's hard to tell. What I will say is that if a 401k is rolled over, very often they're rolled into IRAs. If that asset is still a tax deferred asset, and has still has what we call qualified status, then it does not count as an asset for Medicaid eligibility. However, and remember, it doesn't go into the trust. However, any required minimum distributions from the account will be counted as income. And in Suffolk County, actually, they go beyond required minimum distributions. And if you go on Medicaid and you have this type of account, you'll have to take an advanced rate. So you'll have to take more than your required minimum distribution. I think there's one up here higher about Medicaid we missed as well.
Let's see. Oh yes, okay. So this one asks, once the Medicaid Asset Protection Trust is set up, if my aunt needs a nursing home very soon after it's set up, can the Asset Protection Trust be revoked and transferred with exemption?
So this is referring to the Medicaid look back. So when you create the irrevocable trust for Medicaid asset protection purposes, the current law in New York is that there is no look back for home care. So if I transfer the assets this month in December, then next month they are not counted as my asset for Medicaid eligibility, and there's no penalty for the fact that I moved them out of my name the month prior. However, with a nursing home, there's a 5-year look back. So if I need the nursing home on January 1st, they will go back 5 years and say, what did I give away over the course of those 5 years, and assess a Medicaid penalty, which amounts to multiple months, depending on how much you've transferred, can be many months of care that they're not paying for, which is very expensive. So a lot of people try to do the planning into a Medicaid asset protection trust early to start the 5 years so that they're in the clear if they need that care in the future. And part of the difficult thing here is timing it, because some people don't want to do it too soon, but you also don't want to wait too long if you are looking to gain that protection. So in this case, somebody's asking, what happens if you take the house, you transfer it into a trust for Medicaid asset protection purposes, and then you end up needing a nursing home and the 5 years has not gone by? So this is when we get into the revocation of the trust. So if you remember when I was talking about the irrevocable trust a little earlier, I said it could be revoked. It just can't be revoked on your own. So in this case, there's an aunt. She's the creator of the trust. So she can only revoke the trust if all of the beneficiaries sign off and agree. So yes, if that is the case, then she can revoke the trust, the beneficiaries agree, the asset would go back into her name, and then if we would be able to protect it or how we would protect it would depend on what the assets were that were in the trust and other factors. But yes, we can usually come up with a Medicaid plan when there's assets like that and protect at least some of the assets.
And there's another question here that asks, does a TOD on a house need to be filed with the state to validate the TOD?
So yeah, the transfer on death deed has to be filed. And this is one of the other concerning downsides, especially in busy counties. So it's not with the state. Your deed, when you sign a deed of any kind, it's registered with the county. But the TOD law says that the transfer on death designation, the beneficiary you've listed, is only in effect once it's been signed and filed. But those of us that file deeds understand that there can be a delay based on how busy the county clerk's office is. And if there's a delay in filing the deed and someone dies, well, then that deed is not effective as to that transfer on death and the beneficiary doesn't get it. So transfer on death deeds can be very dangerous if somebody's at an end of life situation, because if the deed is signed but not recorded, and the person dies, it's as if it was never signed. Whereas other deeds actually, so if you were to create the trust and sign a deed to put the house into the trust, that's effective upon signing. And you can still file it if somebody does die quickly. And so you want to be very careful not to try and use transfer on death deeds if you're trying to get something done quickly before someone passes. I think those are our
All
questions.
right. Yeah, I think that's all the questions thus far. Oh, we just have one that came in.
Great.
Um, if someone has regular Medicaid or community health Medicaid, can Medicaid put a lien on a home or co-op?
Um, So I'm going to answer this very in a very broad overview, because the rules as to what can happen with a co-op or a home and liens with Medicaid are very complicated. It depends on a lot of factors, but generally speaking, a lot of people get confused because for eligibility purposes, you can own a property less than about $1 million. So if you own your house and it's worth $400,000, you can receive Medicaid. However, upon your death, if your property goes through probate, Medicaid has a lien on your probate estate. So we often don't want assets to be in your sole name because we don't want Medicaid to put a lien after your death. The rules as to liens during lifetime are much more complicated and depend on a lot of factors, but I think that probably answers that question. But if you do own a home, I think the takeaway should be that if you own a home, you should be looking into planning with that home and what to do to protect it if you are going to need any kind of Medicaid benefit.
And we have another question that came in. Can a pension be deposited into a Medicaid trust even if there's no other assets?
So you don't want a pension to go into a Medicaid trust, because remember, you can't use for this type of trust that I'm talking about today, the Medicaid Asset Protection Trust, you cannot use the money that goes in the trust. So if you're living off your Social Security, your pension, you can't put those into this type of trust, because then you can't use them. Now, there are other ways. If you are on home care Medicaid, if your income goes above the Medicaid limits, there are other types of trusts that we call pooled trusts, POOLED, that can receive excess income so that you can still live on it but use Medicaid. And these pooled trusts are for individuals who are on home care services. They don't apply to people who are in a nursing home. And that might be the better option for somebody who has no assets.
All right. That
Yeah.
seems like all the questions that have come in. Oh, we have another one. I think you mentioned that a life insurance policy can be left to a beneficiary. Um, it, I think it's saying, can it be left to a trust or it can,
Um, Let me see. A life insurance policy can be left to a person, yes, but it can also be left to a trust. So in my example, where I created the Britt Burner revocable trust, the life insurance can be left to my trust and therefore divided amongst my varying beneficiaries, sure. And this goes to the point of when I said just creating the trust isn't enough. You then need to create the plan with all your various assets to make sure you funded the trust properly and that the assets are going where you intend for them to go at your death. I think that's
I
it.
I do as well. If anyone else has any other questions, either put it in the chat or you can raise your virtual hand and I can unmute you. Um, we'll see. And this recording will be made available to everyone once it's processed as well. for people to look back on. Um, we'll give another minute to see if there's any other questions. Oh, here we have a hand raised wherever. Let me, and raised and then I lost it.
Uh,
Let's see. I think it was Linda. So we'll see.
I raised it by accident, sorry.
Oh, all good, all good. We do have a question that says, did you mention the best way to set up funding a nursing home?
I didn't mention that. What I did mention are some issues about the way that people might protect assets with this Medicaid Asset Protection Trust if they're looking to get Medicaid eligibility for a nursing home. But I didn't really go beyond that because it was a little beyond the scope of this. But a Medicaid Asset Protection Trust, which is a type of irrevocable trust, is often used when people feel like they can plan in advance. However, to the point of the question that was asked earlier, when some people do not make it the 5 years, there is some emergency planning we can do as well.
Um, and we have another question here. I believe it's asking, uh, do
I think it's saying,
people
do people use?
use a sole benefit trust often, and what are the downsides?
So we would use them if we have to. A sole benefit trust often has that payback to Medicaid, just like the first party SNT. So we only use them when we have to. But the benefits would be, that obviously in certain cases it's the only place we can put assets to protect them. But the downside is that payback.
And we have another question that asks, if you don't have any beneficiaries, is there any reason to have a trust other than having property in different states?
Well, there's always a beneficiary because a beneficiary is who's going to get everything. So I think this person might mean if you don't have heirs. I'm going to answer it this way. I'm going to say there's some people who come in and uh or everyone who comes in to meet with me, I give them the option of creating a trust or just having a will. I tell them the pros and cons of both. I tell them, depending on the work that has to be done in their case, what both will cost. And the response from some individuals is, well, I'm going to be gone, so I don't really care, and they'll wait and they'll get it, and probate might be annoying, but they'll be fine. And then other people say, well, no, I just really want things to be organized and to go neatly at my death, and especially because I don't have any close next of kin, that's going to be a really hard job for my executor, and I don't want to do that to my friends. So it really depends on the person. But not having any next of kin is the main reason to create a trust and to avoid probate, because you're going to have to find those people no matter what. I mean, we had someone who was an only child. They never got married. They had no children. They were in their 90s, so there was no parents alive. And both parents had come in the 60s or 50s or 60s. I'm not sure exactly when, but had come a long time ago. But actually, no, it wasn't. This was long enough ago. It was longer than that. They had probably come over in the 20s, the parents. One was from the Middle East, the other was from Europe. We really had no clue who any family members were. This individual's executors listed in the will were the friends. If I had met this person while he was alive, I would have said, we need to avoid probate here. But I didn't. I met the friends after he died, and I was stuck probating the will. And it took a very long time. We had to hire a genealogist that could search in these other countries and try to find out who the next of kin were. And it takes a lot to satisfy the court that you've looked for them. So a lot of people will avoid probate for that reason.
Okay. And oh, okay, we have another question that just came in. Um, I am owner with uh my mother, a joint owner right of survivorship, and we both live together in the same apartment. Will Medicaid come back when she passes and want me to pay for the home care she received? If she goes in a nursing home after the 5-year look back period, will Medicaid come back to me to pay back some of the nursing home care?
So the 5-year look back applies to transfer of assets. So I'm not sure if the 5-year applies here. But Medicaid only comes back after death if an asset goes through probate. So if an asset is joint with rights of survivorship, then there's no probate. And so there would be no lien after death. What would happen in a nursing home application on a property that's owned jointly is going to depend. It's going to depend on a lot of different factors. So I'd say you probably need individualized advice on that part of the question. But no, if it's joint with right of survivorship, it will avoid probate and it will avoid a Medicaid lien.
All right. Any final questions for Britt before we come to a close with our program today? Oh, we just had one come in. Without right of survivorship for co-op shares purchased before 1996, if both owners are beneficiaries of the trust, is that sufficient to pass the shares?
It's so interesting because I had the 1996 rule on my notes and I decided not to talk about it. So you got it in under the last second. So what this is referring to is that when a spouse or when spouses purchase a property together, if they buy the property together, the presumption is that it is what we call tenancy by the entirety. That means there's rights of survivorship. So if it's spouse one and spouse two are the only two names on the title, and this is specifically in a co-op. This rule that I'm about to talk about is specifically in a co-op, but all other property, a deed to a house, spouse one, spouse two, own it together, it has rights of survivorship. With co-ops, so if you own shares of a co-op, if the co-op shares were bought before 1996, New York State did not treat that like they treated a deed to a house. And so if spouse one and spouse two bought a property in 1990 and it just had their two names and it didn't say joint with rights of survivorship, then it's deemed to be tenants in common, meaning they each own 50%. So sometimes someone comes in after the first spouse dies, they own a co-op that they bought in the 80s, and they just have their two names on the stock certificate, and we have to probate the will so that one spouse, the deceased spouse's half, can go where it's supposed to go. Sometimes it's to the spouse, sometimes it's not. And so it could create a big problem. If you purchase it after 1996, they changed the law to make it tenancy by the entirety between two spouses. So it has rights of survivorship. So that's the background here. But this person's saying if both owners are beneficiaries of the trust, is that sufficient to pass the shares? I think the answer is yes, but I don't quite understand the question. So if you have two spouses that create a trust, then the trust is going to say what happens when the first spouse dies and what happens when the second spouse dies. We often create two different trusts, one for each spouse that reads as to what happens. But yes, the trust can dictate that.
Okay. All right, we are right at the end of our program here. So seems like that's the end of our questions. So I wanted to once again say thank you, Britt, for coming on.